At 90 years old, Senator Diane Feinstein is the oldest serving member in the United States Senate. In fact, she is the longest serving female senator in U.S. history. She has unfortunately been recently widowed. Her husband, late husband, Richard Blum, died at the age of 86 in February of 2022. Recently, a lawsuit has been filed by Senator Feinstein, or on her behalf, alleging elder financial abuse. My name's Gregory Singleton. I'm an estate planning attorney. We're here to talk estate planning. Today, we're going to look at the dispute surrounding the marital trust of Diane Feinstein. I want to boil it down because I've seen a lot of stuff in the news chasing after shadows. I want to boil it down to what is essentially at the core of this case. But before we get to that, let's talk a little bit about background about Senator Feinstein and the late Richard Blum. They were married for over 42 years. Congratulations to them, by the way. When they got married, they both had children from a prior relationship. They had a blended family. So Senator Feinstein brought to the relationship one daughter, and the late Richard Blum brought to the relationship three daughters. Now, they had no children together. Richard Blum had a revocable living trust. During his life, he set up a revocable living trust, as many people do, and as part of the planning, he set up a marital trust. What a marital trust is that when the decedent dies, their assets get dumped into a marital trust, and during the lifetime of the surviving, usually spouse, payments will be made from the marital trust to the surviving spouse, either on an as-needed basis, as appropriate basis, or as on integrals, whether that be monthly, weekly, quarterly, annually, whatever it may be. It's there so that the surviving, or that the deceased spouse can take care of the surviving spouse. And then at the death of the surviving spouse, so both spouses are dead, whatever's left in the marital trust distributes down to whomever they want. In this case, the presumption, again, I haven't seen the trust, but the presumption is it would go to his three daughters, and whatever was in Senator Feinstein's estate will go to whomever she wants, presumably her daughter. So we've got a situation where we've taken care of our surviving spouse, and we've guaranteed an inheritance for our children. Now, one of the reasons that we do this is if we don't set up the marital trust, let's say that the late Richard Blum left all his assets to Senator Feinstein. Well, Senator Feinstein, when she dies, it would be her assets would be controlled by either a will or a revocable living trust. She has no obligation to leave an inheritance for Richard's three children. So by setting up the marital trust, we take care of the spouse and guarantee an inheritance for all the kids that we want. Now, the allegations in this case are elder financial abuse, and there's two layers to it. The first layer is that the allegations are that the trustee is not making timely or payments at all to Senator Feinstein. They're saying that she's owed money, they're not paying it, and they're taking advantage of her because she's elderly. Very simply. The second layer to this is that if money is in the marital trust and is not paid to Senator Feinstein, then when Senator Feinstein dies, her estate will not include whatever money has not been paid to it and will not go down to her heirs, to her beneficiaries in this case, which creates I would say, a quasi-interested party out of her daughter. Now, a lot of people are making a big stink out of this, and one of the reasons for that is the lawsuit was brought by Senator Feinstein's daughter on behalf of Senator Feinstein under the authority of a durable power of attorney. Could the daughter bring a lawsuit on behalf of Senator Feinstein if she didn't have a durable power of attorney? Absolutely not. She is not a real interested party. But under the authority of the durable power of attorney, she can. Now, some people are saying, well, if there's a durable power of attorney in case, Senator Feinstein must be incapacitated. Well, that's just absolutely, completely untrue. You do not have to lack capacity to grant someone a durable power of attorney. Durable just means it's effective while they're incapacitated. But if you look at like the Minnesota law, the Minnesota statutory short form power of attorney, which if you watch the last two videos that we talked about, they're effective as soon as that document is signed. It does not require that someone wait until incapacity. So it is not evidence of incapacity that Senator Feinstein had a durable financial power of attorney. The second thing that I've heard a few times is that the trustees have not seen proof of the power of attorney. For those of you that are wondering and following this case, in my opinion, as a former litigator, I wouldn't put too much weight on that allegation. Basically, they're alleging that they haven't approved of the power of attorney yet, and they don't know for certain that it's a good power of attorney. That is a common litigation tactic. I wouldn't put any weight in it. Elder financial abuse is a really unfortunate situation. In this case, the stakes on the line are in the millions. If the trustees are found liable and to have breached their fiduciary duty to not make the payments as required, there's going to be some major implications for them. I don't know if there's criminal, but because this is not a criminal case, it's a civil case. But I would be shocked if they ever worked as a fiduciary again. Now, for Richard Blum, looking at taking it back to the individual whose estate this is, it was his final wishes, essentially, that his wife, the Senator Feinstein, be taken care of through the marital trust. If they're not abiding by his wishes, to me, that irks me a lot. I really don't like elder financial abuse. When it comes down to it, the best plans do fail. He's had $1 billion in his estate when he died, and he could have come up with, tracked down the best lawyers who wrote the law on trusts and put something together. Even with the best attorneys and the best trust possible and all the plans well thought out, sometimes those plans fail. That's kind of the bottom line with any estate planning. Our goal is to prevent that as much as possible. And unfortunately, sometimes the only way to prevent that is to litigate. So that is my take on the allegations of elder financial abuse brought by and on behalf of Senator Feinstein. I hope you liked today's video. If you liked it, hit that like and subscribe button. It really helps support the channel. We do new videos every other Wednesday. If you have questions, leave them in the comments below or send me an email. Otherwise, until next time, this is Gregory Singleton with Signature Law.